Today we look at the case of Kenneth Walker, Breonna Taylor's boyfriend, the one that shot at police, and we're going to see if state law makes him immune from prosecution. Welcome to the channel. My name is Nate the Lawyer, and welcome to the Brody's Bunch, where you are the joy of today's content. Now, I'm a lawyer, former prosecutor, and former law enforcement officer. Now, if it's your first time here, don't forget to like this video, share this video, and subscribe to the channel if you like the content. Now, today we look at the case of Kenneth Walker. He's the boyfriend of Breonna Taylor. Now, if you don't know who Breonna Taylor is, she's the 26-year-old black woman who was shot and killed by police executing a no-knock warrant in Kentucky. Now, with any police-involved shooting, we look at two things, the law and the facts. You decide the outcome. As always, we start with the law. And today we're going to talk about the Castle Doctrine. Just so it's clear, everybody understands, this is not legal advice. I don't practice in Kentucky. This is not legal advice. If you need legal advice from a YouTube video, you're in trouble already. So, what is the Castle Doctrine in Kentucky? Well, here's another YouTuber from Concealed Carry, and he's going to explain to you the fundamentals of the Castle Doctrine.
I am just giving you general information about Castle Doctrine and stand your ground. This is not legal advice. We'll start with the Castle Doctrine laws because everyone wants to feel safe in their own home. And everyone pretty much feels the same way. Somebody comes into my home, I'm taking care of business. Well, that's pretty much what the Castle Doctrine laws allow you to do. In general terms, the Castle Doctrine takes away the element of intent. What the Castle Doctrine laws say is that if someone comes into your home while you're inside, that you can assume, and the court must assume, that their intent was to do you harm. And that's very important. Those laws say the court must assume that their intent was to do you harm. That means you have the right to defend yourself with any level of force up to and including deadly force.
Now, Kentucky Penal Code Section 503.55 defines the Castle Doctrine and statute in the state of Kentucky. Now, in Kentucky, if you are in your home and someone is simply break in, the law presumes that you are in reasonable fear of imminent death or great bodily harm. The law also makes clear that if you use deadly physical force against that person breaking in and you reasonably believe that the entry is unlawful or forcible, then you can use deadly physical force to stop that person. But there is an exception, and I like to call it the police officer's exception. Now that means if you know that it's the police who's coming in. For instance, if you either know or have reason to know that it's the police, then you are not justified in using physical force to stop the police from entering your home. Here's exactly what the statute says. If force is used against a peace officer or police officer who enters or attempts to enter a dwelling or residence or even a vehicle in the performance of his or her official duties, and the officer has identified him or herself in accordance with applicable law, or the person using force knew or reasonably should have known the person entering was a peace or police officer, then that person obviously would not be justified in using force to stop police from entering. Now, if a person is justified in using force under the Castle Doctrine in Kentucky, the law states that that person is immune from any criminal prosecution and civil liability. Kentucky Penal Code 503.085. It makes it clear that if you're using force under the Castle Doctrine, you are immune from prosecution. Matter of fact, let me just put it in plain English. If someone is breaking into your home, you're presumed to be in fear for your life. You are allowed to use deadly physical force to stop them. And if you do, you'll be immune from prosecution. But what does that mean? Well, the statute says you can't be arrested, you can't be detained, you can't be charged, and you can't be prosecuted. That's the immunity afforded to you in Kentucky. Now, this has actually been challenged in court. The Court of Appeals in Kentucky, in a case called Lemon v. Commonwealth. Again, all these cases are in the description. The court said, quote, under the statute, a person who justifiably uses force in self-protection of either a dwelling, a residence, or others is immune from prosecution in any criminal or civil proceedings. The Kentucky Supreme Court actually held that the immunity afforded under the statute is not simply a defense, but prohibits prosecution of a person covered in those provisions. So let's just call it what it is. If you are justified in using force under the Castle Doctrine, you are immune from both prosecution criminally and any civil liability. Again, if you're justified in using the Castle Doctrine. Now, in Mr. Walker's case, this is all going to depend on whether the state can prove beyond a reasonable doubt to someone like you that the person knew that the people coming through the door were the police. If the state can prove that fact, then it can prosecute. Now, all the statutes and case law are in the description of the video. You can see it for yourself. Now, one thing I do have to bring up is that the Castle Doctrine really conflicts with no-knock warrants. Think about it. You could have a situation where police have a no-knock warrant and then go and force entry. The person who's inside can start shooting at police, right? They don't know that those are police. Police don't usually call a person and say, hey, the police are coming in to do a no-knock warrant tomorrow, right? They just come. So if that person then shoots and kills officers, the person can easily claim the statute says they should announce themselves. And there was no way I could have known those were police officers. Then that person is immune from criminal prosecution under this Castle Doctrine. Now, one last thing that I have to bring up is that both Mr. Walker and the police can be justified in their use of force. It's not an either-or thing. Now, if the police were justified, that doesn't mean Mr. Walker was not justified, and vice versa. You could have the scenario where both sides are justified in the use of force, even if there was some mistakes. That's the way the law works. Now, let's move on to the case of Mr. Kenneth Walker. Now you understand the law. Let's put it to the test. A couple of preliminary things that I think we need to just dispense with quickly. First, this was a dwelling or residence. Second, Mr. Walker did have a legal right to be there. It was with his girlfriend. And the police had a legal right to be there too, because don't forget, they were executing a warrant. Now, in my last video, we just looked to see whether the police were justified in what they were doing. Now, this video, we're going to look to see if Mr. Walker was justified in shooting at police under Kentucky law. Now, there are some things that you have to be aware of. First, this is March 13th, 2020, around midnight. And the police are dressed in plain clothes. So, the big issue that you need to consider here is the time of day. Are people likely to be awake? Are people likely to be dressed? Are people likely to be outside? All of those things matter when we talk about witnesses, what they could hear, what they couldn't hear, and what's happening around that time. Let's hear Mr. Walker explain what happened when police came through the door.
Being us. We went on a date, went out to eat, went back in the house, playing, watching a movie.
Take us to that moment when your life really changed forever.
It was a loud bang at the door. Nobody was responding when we were saying, who is it?
You all did ask, who is it?
Several times, both of us. There was no response.
The police say that they said several times, it's the police.
If they knock on the door and say who it was, we can hear them. It was dead silent. I know 1,000,000% sure that nobody identified themselves.
So the next thing you hear, the door flies off the hinges. Are you feeling afraid?
Definitely afraid. But I don't have much room to be afraid because I got somebody here that I got to take care of.
So you hear the heavy knocking, and what do you do?
So now at that point, we're getting up to put on clothes, make ourselves decent to answer the door. Then I grab my gun.
We should also say you were licensed to carry the gun.
For sure. That was the one time I had to use it. If it was the police at the door and they just said we're the police, me or Brianna didn't have a reason at all not to open the door and see what they wanted.
So the doors fly off the hinges.
I let off one shot, and I'm figuring if somebody's trying to break in or something, they're not gonna want to do anything after that.
And after that, what happens?
I don't think I ever heard so many gunshots like all at the same time.
You called your mom first.
Yeah, I told her that somebody just kicked in the door and shot Brianna, and she's freaking out at this point, but she told me to call 911, so I did.
911, Operator Harris, where is your emergency?
I don't know what's happening. Somebody kicked in the door and shot my girlfriend.
While you're on the phone, you don't know it's the police.
I didn't know it was the police, not at all. And I even proceeded to tell 911 that, somebody just kicked in the door and shot my girlfriend. If I knew who it was, I would have said the police, or I wouldn't have been calling the police on the police. That doesn't even make sense.
Where was she shot at?
I don't know. She's on the grill right now. I don't know.
Is she alert and able to talk to you?
No, she's not. Breathe. God.
In the midst of me talking to 911, I'm like, well, Brianna's mama should know about this too. I hung up on them and I called her mama.
The police didn't come rushing in?
Not at all. I don't think I realized that it was the police until I was on the phone with Brianna's mom. I heard like people outside talking. I thought they was, coming for help because I called 911.
So you think they're coming to help you?
Yes. So when I come outside, there's guns pointed at me. I'm being threatened with dogs and whatever else.
So he said they were watching a movie. How does that affect now his hearing from the bedroom? Somebody's knocking at the front door. You're in the bedroom watching a movie. That's going to affect whether you can hear or not. He says he had loud knocks at the door, yelling, "Who is it?" Remember, it's midnight. And he claims that they were putting on clothes to get decent to open up the door. Is that reasonable? So now that you've heard his version of events, there are 3 questions that you have to resolve. First, was it even Mr. Walker who shot at the police? Second, did the police announce their presence? And third, did Mr. Walker know that the people coming through that door were police officers? So our first question, did Mr. Walker shoot at the police? Well, he said he did in both the police interview and in the TV interview. But right after the shooting, he said something else.
Who is it? They just started shooting.
No, we down 3 times. Police search warrant.
There's somebody who was dead? Yeah, my girlfriend. It's
Who was shooting at us?
It was her house.
Who was shooting at us?
We have to go in if there's somebody. What is this about? We don't.
Dude, SWAT can come.
We're both just regular workers.
Hey, boss.
Where is she at in the apartment? She's on the ground. Where at? In the hallway.
What kind of gun did she shoot?
It's a regular 9mm. Did she shoot or you shoot it? It was her. She was scared.
So did Mr. Walker shoot at the police, or did his girlfriend shoot at the police? And how does this affect his credibility? Now, our next question is, did police announce their presence? And did Mr. Walker hear them? Now, here we have to go to the witnesses, right? Because the police said they announced. Mr. Walker says they didn't announce. So we have witnesses who can tell us what they heard. So police have hinged their whole theory to one witness who was outside who claims he heard police announce. Here's the Kentucky AG explaining.
Evidence shows that officers both knocked and announced their presence at the apartment. The officers' statements about their announcement are corroborated by an independent witness who was near in a proximity to apartment 4. In other words, the warrant was not served as a no-knock warrant.
Now, the witness that the Kentucky AG is talking about is Aaron Sharp. Now, why is this an important witness? Because he was picking up his daughter above Breonna Taylor's apartment about the same time the raid was occurring. You have a witness who was in the location, who clearly could hear everything, and this is what he told Louisville Metro Police on March 22nd.
Did you hear them identify themselves either to you or to anyone else?
I saw the uniform on there, so I know. And when I looked through the window, I saw it was a lot of police cars, and I saw the armor car was parking on the left hand side. I'm throwing it to me to get inside.
Well,
so when I went through the window, I saw the.
I don't mean to cut you off. I'm sorry. Is this before the shooting or after the shooting?
They were before the shooting.
Okay.
Yeah.
Did you ever hear anyone identify themselves as police?
No, nobody identified themselves.
So he didn't hear the police announce. But on May 15th, Mr. Sharp changes his story. He says, quote, he heard the police say, "This is the cops," corroborating the testimony of the 7 officers at the scene. So the government's one witness initially said he didn't hear the police announce themselves, and 2 months later says that he did hear the police announce themselves. Now, I must also mention that Mr. Sharp was one of 12 witnesses, and the other 11 witnesses claimed that they never heard the police announce, even though some did hear the knocks. We have a position where we have 11 other witnesses who are not in the same position as Mr. Sharp. They were indoors, and it was midnight. Remember? Time and place. It's a fair argument to say they may not have heard the cops screaming police because they just were in a bad vantage point. But the witness who the state says was in a great vantage point has a conflicting story. So essentially, you have one witness who's changed their story, and none of the other witnesses heard police announce themselves. Now, this is your first question as a jury. Do you believe that there is enough evidence to conclude that police announced themselves? Quick review. The police had a no-knock warrant. They weren't obligated to announce. They have one witness that said they didn't announce, then changed the story 2 months later. And none of the other witnesses who were in the vicinity heard the police announce themselves. Does the time of day affect your decision? This is your choice to make. And this choice is critical. Remember why this is so important. If officers identify themselves, then Mr. Walker can be charged with murder, right? He's not immune from criminal prosecution if he knew that they were police. But based on the evidence that you have now, can the state prove beyond a reasonable doubt that Kenneth Walker knew that those were police coming in that door with the evidence that you have in front of you? So let's put it all together. When police knocked on the door, can the state now prove that police announced themselves? One witness who's changed their story, 11 witnesses say now. Can the state also prove that Mr. Walker knew that they were police? 12 midnight raid, Mr. Walker was watching a movie, they were in bed, getting dressed to come to the door in the bedroom. Now, if you answer no, is Mr. Walker immune from criminal prosecution? He was defending his home. The Castle Doctrine says he can do that. So our critical question is, do you think the state can prove Mr. Walker knew that those were officers based on the evidence that you have before you? Now, some people will say, well, he was a drug dealer, he was this, he was that. That is irrelevant to whether Mr. Walker, when he fired that shot, can the state prove he knew they were cops? The comment section is where you let me know what you decide. Now, about the comment section, I read every comment. Now, on these videos, I don't heart comments or respond to comments. And the reason why is that I don't want to influence your decision. I don't want you to come to the video and say, oh, Nate liked these comments, so he's thinking that way or thinking this way. I want you to look at the evidence yourself and come to your own conclusions. Now, just some house cleaning. Mr. Walker was initially charged and arrested for attempted murder and assault. But those charges were dropped, and the court allowed the state to refile if they can get better evidence. But now Mr. Walker is demanding that he be afforded immunity under the Castle Doctrine because he is a licensed gun owner and he was protecting his home. Should he be immune from prosecution? Should he have even been arrested or detained? Remember, the law says if you are in your home and you are defending yourself from somebody breaking in, you are immune from prosecution. Again, that's something you have to think about. And one last thing. If you've watched the video to this point and haven't subscribed, what are you doing? Come on, hit that little button and join me on my journey to 100,000 subs. It's going to be interesting to hear all the comments. Let me know how you came out in the comment section. I'll see you there.